but it was a white elephant. I mean, they claimed his power bill any given month was $1,000 to heat and cool this house. But I mean, it was as beautiful on the inside as it was on the outside. And that's part of what was wrong with this town is this guy had done so much to restore this town. And then when this happened, it just...
Did he get criminally prosecuted?
He was being criminally prosecuted when he committed suicide. Another note on committing suicide, he did it 1 week prior to his oldest son's wedding.
Prior to his son's wedding?
Prior to his son's wedding. Now, how selfish is that? You know, but once again, look at the case that I'm telling you about. His youngest son actually later on ended up getting killed in a car wreck. So, I mean, this was just an entire family devastated, ruined by the actions of one person. The older son actually was a pretty good guy. The younger son was dead in the middle of all this with his daddy, but he wasn't being prosecuted. Let's talk about expert witness testimony. One of my pet peeves when you go into the courtroom is not being dressed properly. If you want to be considered professional, dress professional. That means a suit, tie, sports coat, slacks, tie. Dress like the attorneys that you're going in with. In this day and time, it'll actually help you get into the courthouse because the guards won't look at you quite so hard. But I mean, I don't even understand debtors that go into bankruptcy hearings dressed like slobs. I mean, I understand if you don't have a lot of money, that's perfectly fine. But you can at least tuck your shirt tail in and show some respect for the courtroom that you're in. One of my favorite stories on this is we were doing a receivership hearing, and it was when the state school superintendent of Georgia was being tried for some activities that she was involved in. And the judge allowed us to have a hearing in his chambers during a recess in that trial in the federal courthouse. This was not a bankruptcy, this was a receivership. But we had a hearing in his chambers. Federal judges have pretty doggone nice chambers, I'll tell you that. It was about the size of this half of the classroom, like where the tables are. He had this huge desk on one end, all his law books behind it, this huge conference table on the other end. Well, he comes in his robe. I'm there with my suit. All the attorneys are there. They walk in with their suit. The debtors that are coming in to plead their case as to why their property shouldn't be sold come in blue jeans and sports shirts. The very first thing, and bear in mind the judge is still in his robe, the very first thing that the counsel for the debtors comes in and says, "Your Honor, it's hot in here. You mind if I take my coat off?" I'd have sat there in a pool of sweat before I had to take my coat off when the judge was sitting there in the robe. I can't say that had any bearing on anything to do with the hearing, but we ended up selling the piece of property. They lost what their motion was, and we won ours. So I tend to think that, you know, once again, look professional, act professional, be on time. If you've been in a courtroom very much at all, you've seen people walk in late, it's generally not a pretty sight, especially if the court's waiting on you. The judge will chew you up one side and down the other. Ask for or provide a list of tentative questions. This goes back to the never go into the courtroom unprepared. And practice. Practice. We were talking about it at the break. You can get a list of tentative questions. In fact, you can get a list of exact questions that the direct examining, the attorney that you're there for, that's called the direct examination, is going to ask you. He can give you a list of proposed questions that he believes you're going to be asked under cross-examination. If they don't do that, plant your heels and say, give me something before I go in there. Now, the one unknown is that the judge can ask you anything. You're not gonna know what the judge can ask you. I mean, it can be anything. But practice on those questions. Read over them. Know what your answers are. Know how you're gonna answer them.
And you want to get those how far in advance of the.
As far as possible. I mean, you don't want, not the day of. I mean, I normally like at least a week to have the questions, and then about 2 days before I'm going in, I want to sit down with the attorney that I'm going in with, and I want to go over everything. I want to tell him what my answers are, and I want him to help me script my answers. Nothing wrong with doing that. And I want to go in, and a lot of times, through him talking to you, you can actually give him other questions because of your expertise that he needs to ask you. It builds your credibility. I mean, there's absolutely no downside to doing this and a whole lot of upside. All right, possible direct examination questions. Please state your name and address. How are you employed? How long have you worked for Rival Auctions? Please generally describe your job duties. Do you have any prior experience with other auction firms? Do you hold any professional designations? Value CAI, AARE, GBPA. Have you worked for this attorney, this trustee, whoever it may be before? Describe prior auctions where you worked with him as either a bankruptcy trustee or receiver, and emphasize successful auction results. You know, and what I'm saying there is if you've done auctions for a trustee before at similar properties, say, yes, sir, we've sold, in the past, we've sold 5 auctions for this trustee. On this date, we sold this asset for this amount of money. On this date, we sold this asset for this amount of money. On this date, we sold this asset for this amount of money. You can take notes with you to the witness stand, but be aware, don't take your file with you to the witness stand. Anything that you take to the witness stand can be seized from you and admitted into evidence. And most of us have stuff in our files that we really don't want to be submitted into evidence. I mean, it could be simply handwritten notes that there's absolutely nothing wrong with you having in your file, but in the wrong eyes, they could be interpreted wrong. So don't take your file to the witness stand with you. Tom.
You're doing this as part of your responsibility in the issue. Do you, in your contract, have a separate clause, or should I be called as a witness what professional witness fees are, or is that basically you have an obligation here?
If I'm doing it in a bankruptcy where I'm serving as an auctioneer, I have an obligation. If I'm doing it as an appraisal, there are additional fees involved. And yes, my employment agreement for my appraisal services, I spell out what those fees are. And I will tell you all this, I'm not telling you how to bill, but you charge pretty substantially for this. Has your employment as an auctioneer been approved by courts in the past? If it has, state yes. Describe courts and the property being auctioned. And this is some of the instances where if you've worked for a certain judge in the past, like I've been in Judge Laney's court, piles of times, I'll try to recall something, a case that I've worked on that may jog his memory, that we had a good result of, so that he will remember it. Some of the other judges in the district, I would probably try to recall some good things also, because I actually know all the judges in the district, and I'm going to try my best. Some of them I want to be in their court, some of them I don't particularly want to be there. Not bad experiences, but they can be pretty brutal on you.
You say you like to get together with the attorney a couple days before. You ever had trouble visiting that?
Yes, sir. Yes, sir. And sometimes you won't get that time. Sometimes you'll only get it over the telephone. but really, really, really stress the importance of that. It will make you both look better. I have found that as I have testified for attorneys repeatedly, they don't see the importance of it like I do. Oh, you'll be fine. Just, you know, I'm gonna ask you the same thing I always ask you, don't worry about it, you'll be fine. Even when they say that, I'll still push for a meeting. Sometimes I'll get it, sometimes I'm not, but I will then go back and review the questions that I've been asked before, so that I, just to refresh myself. Any other questions? More possible direct examination questions. Please generally describe how the auction process works. Make sure, not sue. You include a description of the advertising for sale. I actually recently did a auction of a piece of property up in Augusta, and I was in the Southern District in Judge Dallas's court. And Judge Dallas apparently was not familiar with auctions. He hadn't done a whole lot of them. Judge Dallas took over the examination of the poor witness, me, and wanted to know down to how many brochures you're going to mail, how are you going to determine your mailing list. It was going to be an online-only auction. He wanted to know how we found the bidders. He wanted to know how we qualified the bidders. He wanted to know how the contracts were going to be sent. He wanted to know how the earnest money was going to be collected. He basically did not have any knowledge at all of auctions, and he took a real interest in what we were doing, and it was as if he and I were just having this casual conversation of how auctions work. And it was stuff that, unfortunately, I wasn't really prepared for, because I tend to work at a 30,000-foot level sometime, and as far as marketing goes, Samantha Rowell was handling that kind of stuff, so I really had to reach back into some recesses and think a little bit about, okay, well, where are these mailing lists coming from? And who are these brochures going to be sent to? And how far in advance are they going to be sent? And, you know, our contracting department handles sending out contracts and getting earnest money back in, so how do they do all of that? So just try to think through all of those things. Please generally describe how you will be compensated for acting as the auctioneer. A lot of people don't understand the buyer's premium. The buyer's premium is fairly customary. I hear people tell me that they can't use it on bankruptcy auctions. I use it all the time on bankruptcy auctions. So that's going to be regional, whether you can or cannot use it. But a lot of times they want to know how it's going to work. You know, the old argument comes up of, well, if you charge a buyer's premium, then they're just going to deduct the buyer's premium. They're actually going to bid lower, so wouldn't you be better off collecting the commission and commission more standard? Or the people will come to the auction because of the buyer's premium? All those arguments that you've heard all these years that you use the buyer's premium, be prepared to stand up and talk about every one of them again. Have you visited the subject property before? Describe the property to the court. Have you auctioned similar pieces of property in the past? Describe some results. Once again, be specific. Talk specifics about what you've done. If you were to conduct an auction sale of this property, how would you conduct it? Emphasize light advertising, showing the property, the ability of various parcels, if you're going to subdivide it. General description of how the auction process works. If you're employed as an auctioneer in this matter, how are you going to be compensated? In your experience, is this consistent with how auctioneers are generally compensated for auctioning real estate? You know, we talk about Sherman Antitrust and how we can't talk about commission rates. Well, they're going to ask you right there, is that a standard fee of what auctioneers normally charge? What does the term absolute auction mean? What does the term with reserve mean? Will this be an absolute or with reserve? Please describe how you'll advertise this property for auction. Based upon your experience, have you made a recommendation of how this property should be sold? What is your recommendation? Why have you made this recommendation? They will really get down to minutiae in asking you some of these questions. Let's talk about cross-examination. That's when the guy that doesn't like you comes up and starts asking you questions. How much have you earned in fees working with this client conducting auctions? Right, straight off the bat. He's going to tell you that your only interest in doing this is making money. You know what the correct answer to that is? And that's where I normally get into the second one at. Are you recommending an auction in order to generate fees for your firm? Absolutely. Now, and I may say this a little bit later on in there. There are times when you're being examined in the courtroom that yes or no is the only answer. But there are times that yes or no does not fit. There are times that you will be flustered, and there are times, and that's generally when you need to keep your mouth shut, when you get flustered. But there are times when you will be told, Mr. Manley, a yes or no answer is all I'm looking for. Unless the judge tells you that a yes or no answer is all that you're looking for, all he's looking for, disregard that statement. Because if yes or no doesn't fit, ramble on. Because the judge is listening. If there's a jury, and there typically won't be a jury, the jury is listening. And I don't care how many times they say disregard that previous statement, it will still sit. Are you recommending an auction in order to generate fees for your firm? Yes. However, an auction in this case is the best solution for this property because of blank. Whatever that reason may be. So you understand why not stopping at yes is a good thing in this. Tom?
And this, your bankruptcy court, when you have either an absolute auction or a minimum bid subject to approval, in the past, we're allowed to sell the property as long as it made the minimum municipal assessment, which was always the high.
Right.
The trend changed a number of years ago, and now it's by the time, the 1 year by the time they send it to you. So it's your judge, that your court system gives you guidelines that it's got to bring X of the appraisal. We're not doing an absolute unless you, in other words, you have to go back and resubmit this to the court for approval. So when you're selling it, when the hammer goes down, is it selling it subject to the court's approval?
In almost all cases, yes, you're selling it subject to the court's approval.
And that's how you announce it.
Yes. Yeah.
Right? You can have an absolute, but you gotta announce it, it's subject to approval, so it's not.
That's correct. And I do not use the word absolute in bankruptcy auctions.
Without reserve.
I don't use without reserve. I use subject to bankruptcy court approval. I let the bankruptcy heading and selling by order of the United States Bankruptcy Court carry the weight. All right, wouldn't it be better to proceed with a cash buyer now as opposed to conducting an auction? Can you guarantee that an auction will result in more than a traditional negotiated cash offer? You can see these questions are a little bit harder. Isn't there a risk that an auction will yield less than a traditional cash offer? Won't bidders factor the buyer's premium into setting the maximum amount of their bid? Won't this chill the bidding on the property? Have you ever not recommended an auction? Under direct examination, answers with leading questions, i.e. answers that solicit further questions. If you see that your attorney may not be going where he needs to go, or if you see something that could be better for the attorney to ask, if you've got the kind of relationship, you can sometimes lead him into asking you a second question that would get to the point that he needed to handle. Under cross-examination, give short, concise answers, avoid tricky questions meant to confuse. When in doubt as to the meaning of a question, ask for clarification. Cross-examination attorneys, opposing attorneys, love to ask multi-part questions to confuse you and to trick you. I got a fairly short attention span. And I can get fairly dumb when it comes to those kind of questions, intentionally. And I'll just look at the judge and say, Your Honor, I don't understand. I don't understand the question. And I've been known to say it 3 or 4 times in a row, Your Honor, I'm sorry, I just don't understand what he's asking me. The judge will feel sympathetic for you, generally, and look at him and say, well, redirect your question. You know, ask your question, or I will answer the first part of his question and ignore the rest of it. Or I'll answer the first part of his question and say, Your Honor, I don't recall the further question. Break it down into bite-sized pieces. Don't let them trick you. This is one case where it's all right to be a little bit confused. I mean, you can still be very professional, but don't let them lead you with these multi-part questions that if you answer yes on the front end, you trap yourself on the back end of the question.
You don't want to provide information that they don't have.
Absolutely. Absolutely. Harry says you don't want to provide information that they don't ask for. Don't tell them things that they may not already know. All right, that is the end of this class. There's my contact information. Unfortunately, I've been told that in this class we have to do a test also. Well, usually not today. I think we're sort of past reviewing. I will tell you this: we do have a few minutes, probably about 10 before we have to start on the test. And the test ain't going to be anything that you haven't seen. We're actually going to put it up on the screen. So, are there questions? I mean, are there things that you want to know about bankruptcies that maybe I didn't cover?
If there was one little piece of advice to sum up for someone trying to get into this area, what would you say would be the number one thing they should focus on, or the best little nugget? I mean, I know you said an awful lot of really good things, but is there one that stands out?
The biggest issue is that you've got to get some face time with that trustee. And there's no one way to do that. I mean, it can be through networking, it can be through actually getting an appointment with him. Don't assume that just because he's working with another auctioneer, he's really happy with them. Try anyway. If you're not getting face time with him, let's look at Pacer a little bit, try to figure out maybe who some of the attorneys that he's working with are. If you have to get on an approved list in your area, make sure that you get on the approved list. Be prepared to get bonded. There's different things that you're going to have to do. And I don't know, Rob, that there's any single one. You can't read it, can you? Well, hang on, let's do something different. Well, maybe we can you read that? Is that a little better?
Bigger.
I see that far.
Well, I can't help reading. Yeah, he needs more than I can do. If he can't see the screen, I mean, I don't know what he did to his eyes last night, but.
That's gonna be a yes.
Well, I guess y'all have to share a pencil.
I wish I had shared. He can't take a picture. Yeah.
I think I need to ask Tracy because there's pencils right here.
You got pencils?
I got pencils.
Any pencils over here?
Dust.
Okay, before we get into this, I'm gonna make sure I got the right questions that I'm about to ask you. Because it used to be 15 questions and now it's only 5.
We need a couple more. We need one more down here.
Yes, y'all have to put your names on it, but not your member ID number. Just your names, you don't have to put your member ID y'all just power down your, shut your laptop.
All right, Ms. Tracy says that you can't look at your presentation, so
Oh,
it's going to
thank
have to be a
you.
closed book test.
I'm blaming it on Tracy, yes.
I know where you live.
We go from Travis to flex on the structure, not us.
It's all right, Rusty. We've kind of been easy on each other so far today. All right, one more time. You just put your name on the paper, on the answer key, correct?
Correct.
All right, let me get this to a level that you can read it. Okay, this is the rate percentage increase. Is that better? All right. Y'all ready?
Can you make it any bigger?
This is the actual test. This is the actual test.
Can it go any bigger, Mark?
I can go, let's see what it does at 200. It's probably gonna get off the screen up there. All right. Can you read this one? All right, the first question. In what year did the United States Congress enact the first bankruptcy laws? A would be 1800, B would be 1898, C would be 1938, D would be 1979. Choose an answer that best suits you. Choose the correct answer. It's not a trick question. We went over it very early in the presentation.
All right, let's go to number 2 question, as Leslie said. What chapter of bankruptcy is a liquidation proceeding? Key term being liquidation proceeding that is available to consumers and businesses.
what do we need